Assalamualaikum warahmatullahi wabarakatuh. My name is Muhammad Rizwan B. Idris and my metric number is 201812.
Assalamualaikum, my name is Muhammad Mikael bin Muhammad Mustafa and my matrix number is 201739.
My name is Ibrahim Adli bin Usman and my matric number is 200920.
My name is Hilmia binti Muhammad Noor and my metric number is 200896. Okay, today we will be presenting about our topic constitutional supremacy. And in this topic, we will talk about the definition, example, the summary of the article that we have found out, the analysis, and also we will conclude at the end of the presentation. So, welcome to our presentation.
The definition of the Constitution is the fundamental and organic law of a nation or state that establishes the institutions and apparatus of government, defines the scope of governmental sovereign powers, and guarantees individual civil rights and civil liberties. Also, the supremacy means the position of having the superior or greatest power or authority, and the combination of the constitution and supremacy, which is constitutional supremacy, is the constitution is distinct from any other law and in a position of the highest, superior, and the greatest power in authority, and any person need to be abiding by it. About the characteristic of the constitutional supremacy is first, written constitution, which is the constitution of a state needs to be codified in one single document. Next, the supremacy clause. A clause in constitution, either explicit or implicit, makes the constitution the supreme law of the land and other law by the government are subject to it. Next, a rigid constitution, which means the amendments of the constitution require special and difficult procedures as prescribed by it. Next, legislature is not supreme. It is because the legislature derives its power to enact law from the constitution within prescribed jurisdiction and may not beyond the limit as in the constitution. Also, the control executive, which means the executive must act within jurisdiction. And lastly, judicial review. A body or judiciary are vested with power to review laws by legislative and executive and actions by the executive in exercising its power. Here I state the additional notes about the judicial review.
Now, let's take a look at a few countries which apply the doctrine of constitutional supremacy. First, Malaysia. In Malaysia, the federal constitution is the supreme law, the fundamental law, and also the highest law of the land. Any other law is subject to the constitution. This constitutional concept is aligned with the supremacy clause in Article 4 of the Federal Constitution. In Article 4, Clause 1, it is stated the Federal Constitution is the supreme as well as the highest law of the land, and any law enacted by the legislature, including the Parliament, which violate the Federal Constitution will become void. In Article 162, Clause 6, any law existing pre-Merdeka Day may be applied by court, with necessary modification to bring it into accord with the Federal Constitution. In case of ASEAN and government, Lord President Tun Muhammad Sufyan said in his judgment, Malaysia does not apply the doctrine of parliamentary sovereignty as it has a written constitution, thus the doctrine of constitutional supremacy applies. In other words, any law may it be made by the federal legislative or state legislative or either primary legislation or secondary legislation or either in peacetime or wartime or secular law or religious law must be complied with and referred to the Constitution. In upholding this doctrine, the court, which referred to Superior Court, has been vested with the rights to review the actions by the other branches of government, which are legislative and executive. Any party are allowed to make judicial review towards a legislation under these two grounds. First, incompetency challenge, which question the jurisdiction of a legislature to make laws. Second, inconsistency challenge, which can question inconsistency of a law with any provisions under the Constitution, and when a state law is inconsistent with the federal law. The incompetency challenge is a original jurisdiction of the federal court. Meanwhile, inconsistency challenge can be tried in any high court. Judicial review towards the executive is quite wide in nature, as they are bound towards the both Constitution and Act of Parliament.
Another example that can be found is from the United States of America, which US also applies the doctrine of constitutional supremacy as in Malaysia. In Article 6, Clause 2 of the United States Constitution has declared the Constitution, laws, and treaties made by the central government is the supreme law of the land, and all judges of all states are bound by it. Any constitution and laws of any states will be invalid if it found contradiction. As the earliest nation with a written constitution, the tradition of judicial review has also been made by the US John Marshall. The fourth Chief Justice is the one who is responsible in the establishment of the principle in Marbury v. Madison in the year 1798, the first ever judicial review in history. The act of judicial review towards the Congress is more active than towards the executive. In 5 years, there were 31 cases which the Supreme Court found legislation either made by federal or state legislative unconstitutional and void.
The third and the last example nations with this doctrine is Republic of Turkey. Article 11 of Constitution of the Republic of Turkey clearly stated that the Constitution is fundamental legal rules and binding upon legislative, executive, and judicial organs as well as administrative authority and individuals. Any law must not be in conflict with any provisions of the Constitution. In most civil law countries, unlike the common law system, a special court or, in France, an institution established by the Constitution to uphold the doctrine of constitutional supremacy. In Turkey, a constitutional court established under Article 146 of the Constitution of the Republic of Turkey mentioned that the jurisdiction of the court is wide, including to examine the constitutionality of a law made by the legislature, and matters regarding the political parties, for example, the dissolution, permanently, and expenditure.
Next is the summary of the article. Datuk Seri Taqiyuddin Hassan has brought up the case of wanting to implement the Anti-Party Hopping Act. So what is the Anti-Party Hopping Act? It's basically, it prevents politicians from jumping from one party to another, as an example, from Pakatan Harapan to Barisan Nasional. So the enactment of this Anti-Party Hopping Act requires the support of a 2/3 majority in Parliament to amend Article 10, Clause 1, Paragraph C of the Federal Constitution. Article 10 of the Constitution of Malaysia guarantees Malaysian citizens the right to freedom of speech, freedom of assembly, and freedom of association. And an example from this article is that during 1990, the state of Kelantan introduced the Anti-Party Hopping Enactment. Two aduns who had jumped party, the state government has stripped their positions as aduns. These two state assemblymen challenged the state government's decision, and the court later ruled that the enactment was in conflict with the country's constitution. So Datuk Seri Taqiyuddin Hassan had commented on Wanita MCA's proposal on 6 March 2021 for the government to immediately enact an anti-party hopping law before 15 general election GE15 to stop the political fraud culture. And a total number of 60 elected representatives have jumped party since GE14 on May 9th, 2018.
First and foremost, we need to understand what Article 10, Clause 1, Paragraph C of the Federal Constitution is all about. Basically, it tells us that all citizens have the right to form associations, which means that anyone can join any other party they like without any obstacle. In the article, Minister in the Prime Minister's Department, Datuk Seri Taqiyuddin Hassan mentioned that to introduce an anti-party hopping law, the constitution related to freedom of association must first be amended. There are two instances that were mentioned in the article that shows the supremacy of the constitution. Firstly, there is an anti-party hopping law in Penang, but when a PKR state assemblyman, or ADUN, jumped the party, the Penang government does not dare to fire him. Secondly, in 1990, the Kelantan state government enacted an anti-party hopping law enactment. When two ADUNs jumped the party, the state government declared that they have been stripped of their position as ADUNs. Later, both of them challenged the state government's decision in court. From these two instances, it shows that the anti-party hopping law could not be introduced and can be challenged, as long as the Article 10, Clause 1, Paragraph C is not yet amended. The Constitution is the supreme law of the Federation, and any law that go against the Federal Constitution will be void by virtue of Article 4 of the Federal Constitution.
In conclusion, the doctrine of constitutional supremacy is important to any state which are not applying parliamentary sovereignty to maintain internal order. This doctrine signifies the importance of government to sustain and preserve the original spirit of a constitution as it was found. Constitutional supremacy is also necessary to control the law-making activities and act as a guideline for the government to govern the country according to the law and the will of peoples.